enough to be dangerous, but not an expert. That's what I was hoping for. We got we got 9% that are professionals. So for those of you who are privacy professionals, what I was going to share was kind of like the need to know, but it looks like there's enough for you to be dangerous and some non-existent existent to basic. I just wanted to share a few things as a director. I would say as a privacy professional, you should know, right? Just a couple of quick, you should know these things. One is knowing the lay of the land. And most of you guys have probably heard of GDPR, CPRA, right? CCPA. The one thing I want to add though, to try to give you a nugget is also you should know about data localization, right? Because a lot of folks know the big names. We all know those, but most folks don't realize when you have an international company that you are on the board of, that you should also be familiar with the fact that some data privacy laws require you to keep the data in country. And that's not always thought about when folks are talking about processes, marketing, or different business activities. So as a director, I would say, put that on your list, understanding the data localization requirements for the organization that you're on the board of. Another kind of piece of data privacy law that I always throw in there to go with the virtual workspace, speaking about where, is at least know whether or not you have a remote work policy. Because I'm surprised when I ask, do you have one? The answer I get a lot from not just directors, but also management, I don't know. And then you go pick it out and it's like from 1995 and it was called teleworking, right? And it was about for somebody to do it kind of temporarily while they were out for a medical issue. And it's so out of date, but it's still your policy. So I'll just say as a director, those are the two things from a privacy law perspective and from a remote work perspective, I recommend that you put on your list. So that is my intro. I will pass it over to, I think I pass it over to Jessica for her intro.
Thanks, Devika. Yeah, hello everyone. I'm Jessica Heim. I'm a partner in the San Francisco office of BNE, and I focus on government investigations and white collar criminal defense. So I defend my clients in the face of all types of issues, including enforcement actions brought by regulators such as the Department of Justice and the SEC. So as per usual, my job today on the panel is to basically scare you about the key risks for directors related to data privacy and compliance actions for breaches. Since my practice involves defending companies in the face of government investigations, I come into the picture when companies, their directors or management are already facing risks. And these risks usually come in packages. In other words, the government might start an investigation. You might hear from the FTC or you might hear from the state AG. The company will also get hit with a shareholder suit alleging some sort of harm caused by the breach. And then of course there's shareholder activism that could accompany all of the above and usually does. And of course, the fines that are announced publicly, as you all know, are only a very small portion of the costs that are involved with handling, dealing, defending against one of these incidents. As anyone who has been through a government investigation knows, they can be expensive. Well, they are always expensive, disruptive, lengthy, taxing, so that by the time the negotiation phase commences, companies are more than willing to write a check just to be done with the whole thing. But there are all other sorts of costs involved. The litigation costs, of course, can be substantial, especially considering that some of the new laws, or maybe not so new anymore, but the CCPA grant individuals with the private right of action. And up until last year, most cases against directors and officers alleging breaches of duty regarding data privacy and cybersecurity did not get past the motion to dismiss stage because plaintiffs couldn't really establish that directors' cybersecurity monitoring duties were clear enough to form the basis for a Caremark claim. This had been the case with Wyndham, Target, Home Depot, three of the most significant corporate data breaches in recent years. But recently, it was last year, the year before, Superior Court of California, right here in California, approved a settlement in a derivative litigation against the directors and officers of Yahoo for 2 data breach incidents. This was the first significant recovery in a data breach related derivative lawsuit targeting directors and officers for breach of fiduciary duty and unfortunately may be the harbinger of a trend because it kind of establishes that there is now a known duty to act that could support a Caremark claim. So I won't spend too much more time on this, but there's, enforcement by private plaintiffs, state AGs, or in the case of California now, there's a new CPRA created regulatory agency that can start investigations or file charges to enforce privacy laws. And the FTC, I mentioned, being really eager to settle these cases. Well, the FTC likes to settle cases with consent decrees. And if you take a look at some of these consent decrees, they are onerous. For example, I see Davika nodding, but Facebook's, for example, it's 20 pages long, and the duration for many of these broad and ill-defined promises is 20 years. So they can be used to create, further actions down the road. So if you breach one of the vaguely defined provisions, promises from the consent decree, well, there you go. It's almost like violating probation. And finally, I would be remiss if I didn't also mention a recent case from last year against Uber's Deputy General Counsel and Chief Security Officer, a gentleman by the name of Joseph Sullivan, who was brought up on criminal charges by prosecutors right here in our very own Northern District of California for failing to disclose a data breach by cyber attackers who had held data for ransom, demanded a six-figure payout. And of course, I did warn you that I was the scary one, but seriously, until now, a criminal prosecution of an individual company executive was not one of the expected consequences of not having disclosed this type of an issue. So now, we really do have to consider all possible outcomes, including felony criminal charges. By the way, he used to work in that very office as a prosecutor himself. So very strange circumstances. And there were kind of complicating factors in that we can talk about a little bit later, but you're probably sufficiently scared. So I'll pass it over to Mirna.
Thank you, Jessica. So I have to not only thank you for passing it on, but I have to thank you for being the one that's going to scare everybody, because that's usually my role. And I speak quite often on cybersecurity and the threat landscape and the hacktivism community, that I usually get a lot of people scared. So thank you for being the one to take that role today. Hello, everyone. I'm super thrilled to be supporting this group today. As mentioned, my name is Mirna Soto. I have been a technology and cybersecurity professional practitioner. I hate to say the number out loud, but for the last 26 years. I had the pleasure of being the global CISO for a fairly small conglomerate called Comcast Corporation, who happens to own 54 different businesses. I've spent a considerable amount of time in Northern California, as I've served as a venture capital advisor and an investor for a number of firms in the area. But I am currently the Chief Strategy and Trust Officer for a company by the name of ForcePoint. And we provide cybersecurity technologies for companies to do the varieties of security protections, data protections. And one of our cornerstones is included in my title, which is trust, that covers the concept of cybersecurity, privacy, and then the concept of a trust framework, which we'll talk about a little bit later, that's gaining a lot more ground. Last but not least, I am a corporate director and serve on 3 publicly traded boards. All 3 are considered what we like to call critical infrastructure. One is in the energy sector, one is in the transportation sector, and the other is in banking and finance. So you take all of those concepts, and when I spoke before, when I look at critical infrastructure, the cybersecurity landscape around that, and around the data associated with it and the privacy of employees, partners, and then of course, customers. I jumped at the opportunity to join this roundtable discussion, and thank you all for having me today.
And then Mira, if you don't mind, I'm going to pop in because I wanted to, it was good that you and Jessica did this, but data privacy and cybersecurity, we talk about them as separate things, but a lot of times they get conflated. So I wanted to take a minute and just to level set for our conversation, is that data privacy and cybersecurity, the data privacy in many ways is a bunch of different stuff. I know that's a real technical term, but meaning it's got notice, it's got consent, it's got choice, it's got so many things that are with it. And part of it is cybersecurity, right? So you've got this whole world of data privacy, and part of it is cybersecurity. Cybersecurity is keeping data secure. Now, sometimes that data, well, a lot of times that data is more than just personal data, but really when we're in this context, we're talking about cybersecurity almost as a subset of data privacy, because you can have a very secure organization and they're keeping stuff real safe. They're part of the trusted framework, Myrna, right? In the cyber sense, but then don't have the rest of the trusted framework, which is getting active participation of the users, giving the notices as fulsome as possible, and getting the right kinds of consent. So I just wanted to level set that for our discussion.
Yeah, that's a great point, Devika, and I thank you for doing that. One of the things I've often said is that as a cybersecurity practitioner and executive, we often are the stewards of protecting the privacy practices and frameworks in place, but they are definitely not one in the same. So yes, perfect point.
Good. So that's kind of our thoughts we wanted to throw out to you. And Kim said you guys are an active group, so we didn't want to carry on. We can, because this group can talk all day. But Danielle, is there anything else, any direction you'd like to go?
Open it up for questions, comments, stories, what's working, what's not. Cora has a question in the chat box. Cora, do you want to go ahead and, well, it's not a question, it's a comment, but Cora, do you want to go ahead and kick us off and unmute yourself?
Sure, it really wasn't a question, but following on what Devika said, is that the right to be forgotten, a kind of a gnarly requirement of GDPR is not so much cybersecurity as it is, well, a nightmare to CIOs.
Yeah, it's an interesting thing, because the right to be forgotten, for obvious reasons, to your point, gnarly to fulfill. Some organizations, and I will be very transparent based on stories and exposure. I won't quote company names, but there are a lot of organizations though that forget or believe that if the right to be forgotten is only facilitated in presentation versus the security or the encryption of data from a security perspective in their environment, in fact, you have not fulfilled the right to be forgotten. So it's worth noting that you may have a CISO or a CIO come in front of you in the boardroom and say, we're okay because we're obfuscating all of that data. Going back to localization, that is the question. Well, where is it? Have we adequately disposed of that data?
And then I'll play the lawyer for a second and add to the right to be forgotten that there's exceptions. And I say that not in jest, but a lot of times people do, rightly so, kind of freak out about the right to be forgotten. But then there's exceptions to be able to do business, right? Like you can't ask. And this is obvious, but I think it's obvious for us, but it's not always obvious for the tech people who are getting the direction from the data protection officer or from the CPO that says, we got to forget this data. They're like, how do I do that? Right. So we always recommend that when you deliver that right to be forgotten, you deliver it with all the exceptions. And that's part of your process to actually tick through those. Are you still in an active transaction? Well, we get to keep it legally, right? And all these other things. So just want to put that out there as we think about the right to be forgotten.
Great, thank you. Jeff, you had a comment about the payment card industry, if you want to go ahead, and then Purvi, if you want to go after.
No, I was just making the comment that we talk a lot about what the government regulations are, maybe some of the state and international privacy regulations, but I think especially last year as more and more people shifted from brick and mortar stores to online to kind of help fill the revenue gap, that there are certain transaction thresholds that will increase the amount of data protection you're required in many cases by your merchant bank. And for some reason, I just don't think that gets the airplay that many people I think just board members need to be aware of it in addition to all the other things that are brought to you by the state and federal regulators, that there could be industry regulations that you're subject to as well based on the type of industry you're in or your payment channels.
Jeff, I think that's a great point, and I would add to that industry list, if you're in advertising or marketing, or if you're on the board of a kind of B2C, is if your company has pledged to the IAB, the International Advertising Board, or to the Digital Advertising Alliance, they have pledged to abide by certain things, kind of, Jeff, like the PCI DSS. And if they break those pledges, there's an issue. And to make it worse, Jessica, right? FTC can say they lied by saying that they had that certification and pledged to it, and then they lied. The FTC comes after them for being deceptive, have a deceptive trade practice. So,
Absolutely. Yeah, I would highly recommend taking a look at some of those FTC consent decrees to just get a sense of the types of provisions that the FTC includes in there. Like I said, they really are broad and require things like promises to not, not obfuscate, or, just like completely broad and ill-defined, like I said before. So helpful to look at them.
Kirby, do you want to unmute for your comment on Switzerland?
Yeah, thank you so much, Daniela. I appreciate it. This is thanks for the session. I'm actually curious. I know Switzerland has had a lot of strict guidelines around data staying in country for quite some time, right? And obviously with GDPR, CCPA, I mean, all these different variations of regulations that exist. I mean, sort of how do you go about, how do you go about making sure that, all of those variations are understood and that the company is abiding by it? I'm kind of curious to get your perspective.
yeah, it's a thorny one. And Mira, I know that you got some practice with ForcePoint, helping folks through some of this. I'll say from a legal side, I've seen people kind of go the strictest common denominator, but we actually counsel against doing that, because what you end up, it becomes unworkable, right? I tell people all the time, like, you can try to get perfect compliance, but it's not going to happen. Those things are oxymorons to me, trying to have perfect compliance. And so what we talk about is you start assessing the risk. And this is where we talk to Jessica, right? We bring Jessica in and say, okay, Switzerland says this, but how likely, I'm just going to go here. This just is in this group. It's being recorded, I know, but how likely is it that Switzerland's going to come after us, the Switzerland DPA? And you really look at that versus how likely the Japanese DPA is going to come after you. And then you kind of decide where on that scale am I going to go as far as data localization, as far as trying to make sure I have the right out of country transfer. So it really is taking a holistic risk view with somebody like Jessica.
Yeah, and I would add that, we operate in 140 countries, ForcePoint does, and we provide technologies for a variety of industries across those countries. So we have managed through a number of these very strict data regulations. And here's what I would say. Devika made a great point about managing the risk profile, right? Or the risk posture on the decisions that are made around 100% compliance or not. And what are those mitigating controls that you can put in place for quote unquote best effort, right? But knowing very well that those strict guidelines could come back and haunt you from a business process standpoint. However, there are technology opportunities for companies to look into when it comes to containerizing data. And a lot of people will say, well, how can I do that? I'm using cloud-based services. I don't know where it is, things of that nature. And that's a whole other discussion that I don't want to take away from the gist and the scope of what we're talking about today. But in short, what I want to say is it is very possible to containerize data. It is feasible to containerize data in that localized effort. The problem becomes the practicality from a business standpoint, and how difficult will it be for you to transact? In some countries, you have no choice depending on your presence, but there are technology opportunities for you to utilize to give you that edge and to manage that risk. They're onerous, obviously, the regulation is onerous, and the ability to, and the practices to comply are onerous, but I'm going to be somewhat of the optimist and say that it is possible to do.
Great, no, great perspective from all of you. Thank you so much.
Want to pop in with your question on best practices?
Oh, yeah, no, it caught my attention when earlier someone said, you know, the CISO comes into the boardroom and says, we're all fine, everything's okay. And I have an IT background, so, you know, I'm always suspect of everything. And we have, in the boards I'm on, we have a healthy set of things that we review. But I'm very curious if there's a set of best practices somewhere, or even a white paper. I think Rich asked the question, you know, where can board members keep up that are possibly not, you know, technical or and so forth. So what's a good way for a director to stay on top of it? And one of our boards, we never turn it green, the cybersecurity and things like that, because we just feel like it's a moving target. So any insights in that would be really helpful.
Yeah, I'll make a couple of quick comments and then turn it over to the other panelists. But number one, not turning it green is a best practice, because that means it's front and center. It's always on the top of the agenda to discuss, because the reality is you may be green today and the attack landscape changes so rapidly, it'll be different. I'll do a plug for NACD. NACD has a number of really profound white papers and resource materials that are somewhat meant to be educational in nature for board members to understand what are the types of questions they need to be asking in the boardroom, what are the type of metrics that they should be seeing. I'll give you my anecdote. When I first joined my first board, the CIO and the CISO were so thrilled to see me in the boardroom. They said, finally, somebody that's going to understand what I'm talking about. That was a great sign. Very non-technical. That was a great sign of the culture of the company. One of my other boards, they weren't so pleased to see me in the boardroom, because they knew I was going to be asking questions that some of the other board members would not ask. But one best practice there are many, but I also name one best practice, is we often get consumed with data, incidents, time to dwell, things that the technical community will talk through. And you often say, well, how do we know? How do we know? There should be an annual assessment of the security program. And here's my advocation to all the attorneys. And that should be done under attorney-client privilege. Should be a third party that does this assessment. It could be a full range assessment of security protocols and the ability to defend under attorney-client privilege, because there is a very strong chance that there will be discoverable items that you want to manage appropriately.
Great.
And then I mean, well, Jessica, did you want to add, especially when she said attorney-client privilege, I thought about the city case, but go ahead.
Yeah, I mean, I could go on and on about attorney-client privilege and all of the risks involved with privilege in connection with government investigations or internal investigations. You know, one thing that Devika and I had talked about not too long ago was the difference between two cases. One was a Capital One case where they had an incident response, plan. They had thought about everything, planned everything out, had engaged outside counsel to be the one if, should a breach happen. A breach did happen. They acted on their plan. They wrote a report. It was written by outside counsel, but the court there found that it was not protected by attorney-client privilege. And then in another case, very similar facts, Experian, it went the other way. And so why? Same thing. One is protected and one is not. Well, Experian, when their breach happened, they immediately called their outside counsel and asked outside counsel to investigate and write up a report, an incident report. And the court found that because it was done that way, it was done clearly sort of in anticipation of litigation and was meant to be sort of an internal investigative report. Whereas the Capital One case, they felt that because it was done sort of in this pre-planned manner, it would have been done anyway, even if there wasn't like a threat of litigation, because they needed to do it sort of for their own business purposes. The other element for the Capital One case, they didn't really have to get to this element because they already found that it wasn't privileged, but it may have also been, even if it was privileged, the privilege could have been waived because they disseminated the report to so many people that there was sort of like did all of those people need to know about this? This is not for, litigation purposes. So I don't want to suggest that you shouldn't have an incident response plan. Surely you should, but just to think through these elements before, acting on that plan, just putting into the plan, okay, who is the actual client of the, outside law firm who's going to be doing this? Is it, the GC? Is it the board? Who is it? What's the reporting line? And who is sort of in the box in order to make sure it's privileged. So sorry to interrupt you.
No, Jessica, one thing that that may be helpful for you to expand upon, in both of those examples, those were post-incident examples, right? Post-reportable, disclosed incidents. And my reference to attorney-client privilege, and the example that I'm providing, my client was the GC of the company, as an example, was more from an internal assessment perspective where there had been no exposure. So that may be a little, danceable area or gray area that board members and companies need to think about. And the only reason why I mentioned it is because depending on the maturity of your program, you may discover something that now you are legally required to immediately take action on. And that privilege would eliminate the circle of awareness to a small number of people versus it becoming a PR nightmare without incident in hand.
Right. And then I said it is Capital One. And with that too, Myrna, on the proactive ones, we actually recommend that you have, and it doesn't have to be me, but someone who does this side. So Jessica does like the post, hey, it's all gone wrong, I'm investigated side. I do the kind of standing up a data privacy compliance program. And as part of that, Myrna, we suggest having an assessment done, but we say it's at our direction to help us provide advice about policies. So that helps it loop into attorney-client privilege, because it's not just being done for the sake of being done for the CIO. It's being done to help the lawyer advise the company on how the policy should make. And I see Rich smirking. He may not be smirking at me, but I get it. It's a game. It's a little bit of a dance, but it's an important dance, as you see by the case that Jessica spoke about. Yes.
This is all great information. We had a question from David on precautions that can be taken. David, would you like to unmute and pop in here?
Yes, sure. Thank you. Yeah, I serve on the board of a freight forwarding company called Pilot Freight Services. It's my private equity firm owns a company. And one of our vendors is a company called Forward Air. They're a transportation line haul carrier. So we use them for domestic trucking. And their software was hacked by somebody in the dark web, basically making demands on them to extortion to pay them, cash to get out of the hacking, or they were going to release all sorts of confidential data on the firm. And the way it turned out is they ended up paying the hackers, which I just found, incredulous that a large, billion-dollar public company is paying these folks in the dark web, as opposed to, getting it reported and, getting the FBI or, some law enforcement agencies engaged. And I just wonder if anybody else, and fortunately it wasn't our company, but it was one of our biggest vendors. And I was just curious as to how other people have any experience with that type of thing and making these kinds of, extortion demand payments.
Yeah. Let's see if the other directors want to chime in on dealing with that.
I'll comment on the video so you can
Okay,
see who you're talking to.
I mean, I will say that we deal with folks who end up paying even though we're not on the instant response side as much when we do deal with it. And look, people pay because they don't have any other option. So it's, and that is why the amount that ransom, if you look at the stats from the Verizon report, which is another source, somebody was talking about sources, the Verizon report is a source for what threats are most popular and what's happening. But folks are paying the ransom and it's getting higher because they haven't done what Myrna just talked about. They hadn't done the backup, the recovery. They didn't have another choice and they needed their data. So they're like, I pay this whatever. Now it's up to, you know, hundreds of thousands. It used to be 1,000. You remember that? Like 10 years ago, it used to be really like piddly. Now they know they can ask for more and get it. But but it's because they don't have any other options. One thing I will say though, if you decide to pay the ransom, be careful of CFIUS. I'm not trying to be funny, but there's all kinds of OFAC issues, and you know, when you start deciding to pay the ransom, you should definitely do that in coordination with counsel and trying to figure out if you can figure out where that payment's going.
I'm so glad that you mentioned that, because that is, you know, one of the things historically, you know, over the last 5-10 years, last decade, ransomware is not new. You know, it's existed for quite some time. But, you know, at the end of the day, and I've been very unpopular in my commentary, including in the boardroom, to say we would never pay. And the reason why we'd never pay is you cannot be guaranteed you will be released from a second attempt or a second incident. And, you know, our philosophy is to work, you know, through the appropriate legal channels and law enforcement, but it also requires us as board members and stewards of the strategy of the companies to understand what are we doing to give ourselves options. So Davika said, you know, people pay because they have no option. Well, from a risk management perspective, our number one duty is to make sure we have options.
Yeah, and I'll just chime in. Obviously, it's all well and good to get everything set up so that you don't end up in that situation, but that is not life, and that's not what tends to happen. What we do see, you know, Davika said, we see that companies end up paying. You know, there's a difference between paying, such as Uber did in the case I mentioned, and not reporting that to anyone, not reporting it to the FBI, not reporting it to the board. In that case, the deputy GC, who was also the chief privacy or chief security officer, he kept the incident to a very limited need to know group of people. So not even the board found out about it. And in that case, he just so happened to be at the same time testifying or speaking informally, I don't know which, to the FTC about a prior breach that he had no involvement in. It happened before he joined the company, but because he was there in front of the FTC giving testimony and he didn't mention the new breach and the fact that Uber paid the 6-figure ransom, it really upset the regulators. So they just thought that the fact that he didn't actively disclose it, you know, they categorize it as that he covered it up and he lied. He didn't necessarily lie, but he did cover it up. He kept it very restricted, but he was charged with obstruction of justice and charged, you know, criminally as an individual. So, you know, and kind of like the Yahoo case where these egregious facts create bad precedent, you know, now you have statements from the U.S. Attorney's Office in the Northern District of California, like, you know, concealing information about a felony from law enforcement is a crime. While this is an extreme example, you know, don't help criminal hackers cover up their tracks. Do not make problems worse for your customers. Don't cover up criminal attempts to steal people's personal data. And so by saying that, they're basically creating this expectation that if you don't actively report this, self-disclose the breach or the ransom, attempted ransom, that you yourself are violating a federal law.
It's it's a huge conundrum. I mean, it's a huge conundrum. And if we go back to the element of privacy, right? And more often than not, a data exfiltration could present a data privacy violation. One of the things, and I know that this is probably going to be like a grenade here, is we have our regulations, we have our controls, we have all of the things that we need to kind of put in place, the frameworks to ensure that we are complying and securing. At the end of the day, what we need to do is stop shaming companies for having incidents. More often than not, people don't want to involve law enforcement because they're worried about the shaming element. And the reality is that there have been ransomware cases that have been paid, but have been paid for the purpose of working with law enforcement to mousetrap the adversaries. We don't hear about those. I'm aware of them only because of one of my previous lives, but it's definitely a very, very difficult subject to navigate.
Well, even the US government, as we know now, suffered a massive breach earlier last year. So yeah, it happens.
Tough stuff, folks. Let's take it over to Nora. She had a question on takeaways from the SolarWinds incident. Nora, do you want to unmute?
Yeah, sorry about that. Yeah, I was just wondering with you guys, I'm sure you study all these cyber incidences. Is there anything at a high level from this whole SolarWinds saga that we can take away from as board members? How can we learn from this and be better?
So I'll say this, and I've already had this come my client's way, is start asking. I mean, it's a real thing. People are asking, how were you affected by the SolarWinds incident? And if so, how? And I would do that through Nora telephone, right? People try to somebody sent one of my clients a written questionnaire. I was like, heck no, don't you answer that. Like, whatever you do, don't answer that. Said offer a telephone conversation. So if anything, SolarWinds has highlighted that we are all connected, and that everybody who thinks they're, fine should be ready for questions, and it's made it normal, because I've gotten that was one questionnaire. The rest of them have just been phone calls that we've been fielding and taking for them, where we talk through what they're doing with the incident. So from a board perspective, I'd say is ask the question, and ask if your management is asking the question of their vendors. Go ahead, Mary.
It could be a great opportunity for executive session with a couple of the technology leaders of your organization, should you reside on the board and want to have that conversation. The SolarWinds incident, what it exposed was the massive reach and power a particular provider has over the infrastructures and assets of companies, which in turn, my prediction is, will result in other regulatory constructs and legislation around how do we legally protect ourselves from third-party risks like this, from a liability standpoint and things of that nature. Ironically enough, the reach that SolarWinds, and I don't want to pick on them because there's a thousand reasons why what happened. But SolarWinds, I'm sure that there are companies out there that have been using SolarWinds for IT support and things of that nature, and don't really know what kind of data did SolarWinds have access to. Going back to Devika's comment about localization, where was it? Did you use it? Did you take it? Where was it? And I'm going to just be really obtuse and tell you that a lot of people don't have those answers. And it's going to be an interesting thing that we'll unveil over the next year.
And that was John's point in the chat, Myrna. It's so true. Like we're talking now as if it's resolved and we know what's going to happen. Like I said, folks, we're just having conversations about what people are doing. Notice I didn't say we have a conversation about how it's fixed and never going to happen again. We're just having conversations about, so how has it impacted you right now?
I mean, even I mentioned the US government, but even top cybersecurity firms are getting hacked themselves. Last month with the California firm FireEye, it's one of the world's largest cybersecurity firms, and it announced it was attacked by highly sophisticated foreign government attack, compromised its software tools. And those very tools are used to test the defenses of its thousands of customers. So, how do you move on from that?
it's a proven validator that no one is bulletproof.
Mhm.
Jeff, I'd love to hear from you. You've made a number of good points here in the chat, and your recent point here on cybersecurity and disruptive events is interesting. Do you want to pop in here and expand on this?
Are you talking to me, Danielle?
Yes, sir. Yes.
Yeah, so I'm on the board that I serve on, Envision Communications. We're part of the Communications ISAC. And it was interesting on Christmas morning that we got called to do a emergency conference call related to the Nashville event. And I think what was very interesting to me as a board member was that after the explosion, the 2 floors of that building actually filled up with water when the sprinkler system turned on. So electricity and communications gear don't mix very well. But what was very interesting is as we started to roll trucks towards Nashville, in addition to having to deal with the water issue, we also had to deal with the fire marshal to go in and tell us whether the building was safe to enter. We had to figure out what credentials were valid for people to come in on. And then finally, the fact that law enforcement was trying to hold us back from coming in and restore services because it was an active crime scene and they were trying to collect evidence while we were all standing there in our trucks burning diesel, waiting to get in and turn things back on. So I'm sure there's a lot of people that were concerned about 911 systems not being up. It was impacting first responders and stuff like that. But I think it's just a really good example of, doing a tabletops exercise and learning from an actual event and seeing how you would react and how quickly you could bounce back from that. I think there was a lot of lessons learned, and I hope that unfortunately it was a bad tragedy. But I think that from a business continuity perspective, I think there'll be some good lesson learned that board of directors can definitely take back to their organizations and implement as part of their tabletops exercises.
Which Jeff, I echo participating in them as board members is, we always recommend that you have a board member participate so that the management behaves appropriately. To have one of you guys kind of there heightens it, and people, well, I'm here, it's true. Some people will like blow it off, but if you say a board member is going to attend, everybody all of a sudden is present. So it really makes a difference, not just for you as the board members, but it makes a difference for those others who are participating in the tabletop. So I think it's a great point, Jeff. And that is one of the reasons why I try to say information security, though I get lazy and I say cybersecurity, because it's so much more than cyber when it comes to security. So thank you, Jeff. Those are great points.
Do we have any other questions or comments at this time?
Yeah, I put some stuff in chat. We haven't talked about APTs, advanced persistent threats. And I put the comment in, maybe it's a metric, ask your CIO how many times they meet with their FBI special agent in charge. I like to, when I was a CIO, start the relationship before I needed it. Okay, and there was one call, the FBI called me and said, we've detected an APT in your system. And I gave the only right answer, which is, we know, and we're watching it. For people who don't know, an APT is a threat usually from a nation state, not always friendly to us. And they have numbers. In Chinese, they have a big drive to get intellectual property, including things like org charts and memos, because they like to replicate our success. And the most famous one was the Caterpillar replication. So I just wanted to throw that out there and to go along with Jeff. And I'm on the board of an engineering and architecture company in Nashville. And following that event, AT&T coverage went out. So people on broadband for AT&T, that was, I forget how many hours / days that was, but that was another fallout from that.
Cora, that's a great point on the APTs. And one thing that I would encourage you, the concept of trying to steal org charts and things of that nature, very often the nascent motive is not understood. So I have been involved with circumstances where a company will say, oh, well, all they took or all they looked at was X. And I said, no, hold on a second. There's a 6 degrees of separation here that you're not realizing. The org chart was important to do a targeted phishing attack. That's important to then now be able to compromise a data store of an administrator the whole trail of why it's important. I've often had companies say, well, I'm not that attractive to the hackers. Yes, you are. You are attractive to the hackers. Doesn't matter what industry you're in, because there are so many linkages that we have industry to industry, partner to partner, that very often people cannot decipher what was the motive for that particular type of attack. And looping it back to privacy, at the end of the day, the data types is what we really need to be concerned about, is to understand what sort of privacy regulation violation we may be faced with. Number one, should it be used, exposed, and then our disclosure requirements. But you're absolutely right about the APTs. Last thing that I will say, because I would have to turn in my cybersecurity practitioner card if I don't mention it. We have domestic adversaries. Don't fall in love with everyone being a nation state, China, Russia. Yes, the nation state does exist and it is a real threat, but we have domestic adversaries out there as well.
One further thing, it comes back to your employees' awareness. After the APT call, I was having lunch with the chairman, the CEO, and one of the EVPs, and I described this. And the EVP said he's made a statement like they were after credit card information. Okay, so totally, misguided there. And when I was CIO of a large global engineering company, I went with my CISO to brief the board, not just the audit committee, but the full board on the risks of, cyber intrusions. And the board asked, well, what's the worst thing that can happen? And my CISO started giving a very dry cyber response. And I said, no, let me do this. I said, the worst that can happen is that they hack into our system, get our engineering plans, and they have the layout for an oil refinery. They go plant an incendiary device and that blows up. And then we've got loss of life, loss of a customer, and loss of reputation that will take a long time to rebuild, if ever.
Cora, you just won the scary, being the scariest one, but you're spot on. You're spot on.
Quite the prize. We have a comment from John on something he saw at CES last week.
Yeah, so last week I was at CES, and one of the panels was actually the chief privacy officers from Google and Twitter and Amazon were all on one panel together, which is obviously a rare event. And one of the things that they kept on talking about, which I thought was very interesting, so this is kind of a shift in the discussion. Oftentimes privacy is equated with hard to use, something that consumers and businesses won't do because it's an extra step in the process and everything. But they kept on talking about how privacy and ease of use can be and should be the same thing. So that is a shift in the discussion. Does that sound like just marketing to you because they are talking to the CES audience, or what's your opinion about
okay.
that?
So you see me get excited, Myrna's getting excited too. I think that's absolutely true. And I know that first, like, really, Davika, you're just a geek. You think it is, but it really is, because I'm also a tech person. Like, I just can tell you, like, I use the same tech that I practice. And I will tell you, I've been more impressed with Apple's kind of ease of use with the privacy as I go than I have been with anything else. There's something called privacy by design. That's why I got excited. That is really key, brought up by the former commissioner of the Information Commissioner of Canada. But still, it's 7 principles that really can guide your organization. And if you do it up front in that proactive, not reactive way, if you think about it through the whole life cycle of the user, then it's not hard, because it's privacy by default through the whole thing. And nowadays, all studies show, especially these millennials, I'm not one, but these millennials, they care about privacy enough. Like they'll trade it. If you give them the right incentive, they'll trade it away. Yeah. So you can still get your data. You keep your data scientists happy because you get your data, but you've been really transparent with it. So I'm speaking fast because it is an exciting thing. That's not just fluff. If you do it right, you can actually get everything you want and still comply with the law, right? And still treat users with respect if you do it from jump and don't try to wait until something bad happens and try to backtrack and say, no, we didn't mean to do it that way. So.
But Davika, did you really read the terms of service? I mean, I shouldn't say that to you because you did.
I was gonna say, yeah.
Yeah, you did. But the average consumer doesn't.
It's true. That's right. Well, but now they have these little sharing icons, and this is another thing that I've been working on doing visual contracts too. So to go total for those lawyers in the group, and getting away from a bunch of words. And so you're laughing, Rich. Rich laughs at me. I see this. I can see it. But these visual contracts, it's the idea of bringing it down to a level where people understand what they're trading, and they're trying to do that with privacy. So you click on something like the cookies. And TrustArc does this. OneTrust not as much, but TrustArc has it. Whereas when you click on functional cookies being gone, they tell you what you're missing, and it's just being transparent. It's like, you don't want functional cookies, that's fine. You also lose, your login information being saved. You lose loyalty count, and right. So it's showing that trade-off in a way that's meaningful. And even if you don't have to read the whole thing, Myrna, it at least showed it. So if a user can't say they didn't know and start a plaintiff's lawsuit.
Yeah, my comment was a softball for you to get there. That was perfect.
Thank you. I appreciate that. We work well together.
Davika, I have to say I 100% treated my privacy for TikTok as soon as it came along. Before that, I consider myself a privacy stickler, but TikTok came along and here we are, traded it right in. I did have a question come through earlier from an attendee, and it shifts us a little bit. It's on employee monitoring. So employee monitoring has long been a sensitive topic, they say, for privacy advocates, but employers have now justified this monitoring as necessary to conduct business and keep its network secure. So with COVID, employee monitoring has extended beyond the traditional workplace, as we all know, and includes contact tracing, monitoring employees' health, their temperature perhaps. So what privacy principles or practices should directors keep in mind when advising on finding the right balance in employee monitoring? Doozy of a question, but there you are.
I'll just jump in and say that we talked about this a little bit before this panel started, but it's no different than what you should have before, right? In that you should already have a data governance program there. If you don't, this is definitely a good time with a virtual workspace to get data, meaning knowing where your data is, knowing who has access to it, and knowing what you're doing with it. But one thing to remember too is employee privacy in the US. So I want to caveat that because I think somebody said they have international organizations. Know that what I'm talking about now is a very US centric view, because in the US, as long as you've given the employee notice and it's kind of within their expectations, you can monitor. It's kind of scary, Daniela, the tools that are out there. I found some when I was looking that you can really monitor how almost eyes on screen, like whether or not their keyboard's moving. I know, Myrna. But anyway, those tools are there for the US. Now, internationally, there may be some issues, but monitoring can be done if it's under the idea of security. That's why I just want to say, once you put monitoring under security, even internationally, you can find some remissibilities. When you're doing it for other purposes, there may be issues, but now is the time to really start thinking through, not monitoring your employees for productivity, but really helping them understand the risk and using that for education. So the principles, I would say, are the same that exist for any other fair information practice principles. So I'm going to go there again on privacy side. There were 9% of you who are privacy professionals, so you know these. But like the idea of notice, choice, consent, access, participation, enforcement, and redress also work here. If you're going to be collecting employees' health information and temperature as they come in, tell them, right? Don't let them show up their first day trying to get back in the office and not know the temperature is going to be taken, or how long you're going to keep it, or whether or not you're going to report if there's a positive COVID case. It really is about that disclosure.
I would just add, and this is sort of a different point, but about monitoring, again, I come in when things have already gone wrong and we're trying to kind of figure out what went wrong. It used to be that emails, provided like the smoking gun email, the smoking gun evidence in a case. Well, people are using email less and less, but in this remote working from home environment, the use of instant messaging apps has, I would think, increased like exponentially. It was already increasing before just because it's practical, it's instantaneous. It provides, seamless communication when you're not all in the same place. But what I'm seeing in a lot of the investigations that we're working on now is now the gold mine of where people write things that they shouldn't be writing. And, on the one hand, it's good because the company needs to know, what's going on. But employees are really kind of either misunderstanding that their instant messaging apps can be saved just like emails can be, that they could be monitored just like their emails can be. And they are, super informal in terms of the communication styles, and I think really have a false sense of security. So, one thing, and the Department of Justice actually chimed in here. First, it said that companies couldn't get any sort of cooperation credit or leniency credit if they allowed their employees to use ephemeral messaging apps at all. They then backed that down and said, okay, we hear you, that's not practical for business, but you need to put in adequate safeguards and be able to retain the data just like you would if you have a litigation hold, if you have a document, retention directive given, and if you don't, then that fact alone can be used against the company in terms of cooperation credit. So that's a little bit off topic, but it's definitely an important thing when we're thinking about all the different ways employees are working in this COVID environment, working from home environment. The use of these messaging apps is increasing a lot, and employees should really be trained on, what will last forever, what won't, how these things should be used, whether they can be monitored, whether they are monitored from time to time.
Yeah, and I would add to that, just because, we hear certain things and think about all of the messaging and collaboration platforms that exist. There are thousands, if not 10,000, but things like Microsoft Teams, yes, there is some linkages to that. There's a product out there called Slack, which is another collaboration tool. So all of those collaboration tools, anything that may exist where employees can talk to one another. Oh, and if you allow third parties outside of the organization to also communicate and collaborate, would go into Jessica's ecosystem of need to know what will last forever, what's the appropriate use. I want to take a second to go back to the monitoring question or the comment about employee monitoring. Often the concept of monitoring employees is automatically seen as a privacy concern. Like I've had so many customers for our organization, we provide behavioral analytics around behaviors that our employees do throughout a network or through systems to be able to assign a risk score to what the person is doing and how they're behaving. And the intent is not to be big brother to the employee, it's to be able to spot anomalies in your normal heuristics of your organization, which in turn is protecting employees. Because more often than not, we are identifying what we call a hijacked account. So credentials, someone's logged in with Devika's credentials, looks like Devika, sounds like Devika, until that behavioral analysis says, wait a minute, why is she doing the following activities that have nothing to do with her job or have nothing to do with the scope of where she's at, things of that nature. So I personally, as a security practitioner, believe that the monitoring, but the analytics behind the monitoring is where the powerful piece is. And what we've done and what you should expect from technology providers that your companies buy from to do this for you is exactly what Devika mentioned was privacy by design. One of the things that we incorporated in our user behavioral monitoring and analytics platform is that we pseudonymize who it is. There is no name associated. And only until an incident or an investigation is escalated to the general counsel is that individual's name revealed in order for us to protect their privacy, number one, because it could be an error. It could be, again, a hijacked account. And number two, one of the things that I'm working on from a trust framework is to eliminate any type of biases that could flag someone as high risk just because of some pattern of behavior that's not necessarily malicious or nefarious, but just happens to be either culturally or regionally acceptable. So just think about that as well.
I think, David, you had a comment you wanted to make?
Yes, the reason I disappeared off the screen for a second, first of all, thank you. It's really exciting. This is my first meeting with the group. I'm on the board of the San Francisco Chamber of Commerce. This is a very timely discussion. Just this morning on a Zoom with a client that shall go nameless, we were hacked in the middle of it. And the first image was porn, gratefully short, but then there were several rock bands that came in. It took us 10 minutes to get the meeting back going. And literally just now, while I was listening to your presentation, my cell phone rang. And of course, I don't answer any number that I don't recognize ever. But when I heard the voicemail, it said, "Oh, please call us right away. Your social security number has been taken. Please call to confirm your number." Of course, it's a scam. This happens even though I'm unlisted in several, different services. This seems to be happening more and more. Is there anything to be done about this other than telling our clients, don't click on a link you don't know and don't answer a phone call from a phone number you don't know?
Meredith, I know you guys have some technological solutions, but I will say this, David, it's going to get worse. And education, I cannot outweigh the value of education of your employees, especially in this remote work environment, because we had attempts even here at the firm with Postman remotely. I think the stats are it costs $137,000 more for a breach. It's more likely. All the data shows it's going to get worse while we're still remote. But this employee had been trained about the attempt, and it wasn't just a regular phishing attempt. It was like a very complicated social engineering, like a call and everything. But because we had said, hey, always call, they called the help desk. And the help desk is like, we didn't send that. And then through that, we found out. So I'll just give that as an example to say education is all you can do because it's only going to get worse. But Meredith, I know you have some other technological pieces.
Absolutely. So we often say our greatest weakness is the human element. We also say the human element is our greatest defense, because that same human element has the ability to ask and to be inquisitive and to not necessarily just follow a request. I remember back when I was the global CISO at Comcast, we ran a number of campaigns to educate people on what we call, you hear phishing attempts, and we called them executive spear phishing because they were very targeted with a lot of really precise data that people would fall for, to the point where that education got so good that legitimate emails were questioned. That is when you know that you've done a good job. When I would get the HR leader of the company call me and say, "Hey, Myrna, I don't know if this is really legit." And I look at it and I'm like, "It is, so you're fine. Thank you for calling." Right? But it's really, it's a human defense, but there's also, obviously, there's trends, there's campaigns, there's things that people do. That phone call, please call to confirm your social security number. On one of the providers, and I don't want to pitch a provider, but on one of the providers, they'll label that as potential spam, because I've gotten that. And it's only because there's enough knowledge about the origin and where the mechanism is coming from that we could take some preventative measures. But I couldn't agree with you more, Davika. I mean, we have to continuously educate people on the trends that are happening, the techniques and tactics that are being used, so that we can continue to kind of at least protect ourselves from that human error.
I mean, as a board, I think somebody put in there, if you don't have a CPO, how do you make your privacy checked? I'm not sure who said that, but it was a great question. Right. Oh, Kathleen. Yeah. And I think one of the things, I mean, this kind of works out is, are they running, just ask as a board member, like what are we doing as far as phishing? I know that's more cyber, but it matters with privacy too, because it lets you know how folks are thinking about data. The data mind of folks is both cybersecurity and data privacy. If your phishing scores is doing, I'll call it fake phishing, PHAKE. But anyway, fake phishing, if your scores are really bad for the organization, they're not handling personal data well anyway, because they're not thinking about it. They're not thinking about data governance, because personal data can only be handled well if there's great data governance, not just for security, but from the beginning of collection, like what's being collected. And so if I'm you, Kathleen, if I don't have a CPO, I'm asking somebody to tell me what's going on in marketing and how products are developed. And we'll send out slides after this that we didn't use because we want to disrupt this great conversation, but it's got in here some questions to ask, like, hey, how do we develop new products? Because if you hear, well, somebody has an idea, and we go, and there's no mention of privacy and how it's going to be a part of it. And then ask some questions about, okay, so how often do we have to get our privacy notice? Real simple. Oh, we did it 3 years ago. Okay. Now I say semi-annual with the way CPRA is, and not even just annual, like semi-annually, if not every other month. I know your practices are changing. So Kathleen, I just want to give that example to say phishing is a good way, but also those other ways are ways to kind of check the privacy box when you don't have a CPO.
I think we kind of skimmed over this before because the message was that you should already have a lot of these systems in place even before COVID. But I would just add that, you know, there are a significant amount of new risks with people working from home, you know, on less secure systems, sharing Wi-Fi networks with other members of their households, you know, maybe being on a Zoom call when your other member of a household is also on a Zoom call, and you might be talking about confidential things, sharing printers, all sorts of things. So it is really vital that not only do you have those systems in place, but that employees know about what's expected of them in this remote environment. I think we had, even before this started, one of the examples is, you know, you might be talking about something confidential in front of a digital assistant like Alexa or Google, and right before our panel started, that literally happened. Davika said something about something.
Major changes, yeah, and Google.
Major changes, and Alexa answered her.
Oh my God.
So, and Kim, oh, go ahead.
Sorry, go ahead. I said we have time for about one more question before we do closing remarks from the three of you. So Kim, would you like to?
I just thought we could maybe, as we're closing up here, if you could maybe mention maybe a top new threat that we may not have been aware of that you see coming. And you know, what keeps coming to mind is AI and kind of the entanglement with data privacy. But what in your view is something that we may not have discussed or may not be aware of that we should kind of keep a line of sight on?
I'll share, it kind of piggybacks Jessica's most recent comments, but this massive convergence to remote work, I think that the proliferation of data elements that we're not even thinking about, so Alexa's one, unplug her please, but things like Alexa would be one, but then when we think about the fact that many people are using shared devices in a remote work environment. We're also using our home networks that are not necessarily, well, more often than not as secured as a corporate network. Even in instances where you may be in a company where someone says, oh, don't worry about it, we're using a VPN. We're using a VPN with two-factor authentication. Really? That's not going to protect you in a home network environment. That's not going to help protect you in a shared device where data may be stored. That is not going to protect you when you as a board member or an executive member of management is talking about an M&A deal and someone overhears you in your home and you are accused of potential, you know, insider trading or things of that nature. I think that we have no idea the amount of proliferation that will happen because of this remote work environment.
Yeah, I agree with that. Oh.
Go ahead.
I was just going to say, I'll add to that, the remote work environment, on top of that, data aggregation is coming. And I know that it's actually a boon in a lot of ways, right? The fact that we've got more data that can turn in information, we can make better decisions. Kim, kind of your AI point, but I want to move it a little bit further back and say, from the board perspective, don't dismiss what's being done with your company's data. Because a lot of folks are like, it's just data, but personal data is now the definition is expanded with CPRA and the other state laws. They're expanding it beyond what you think it is. It's not just name and phone number and social security anymore. It's their IP address, it's MAC. And so when you're letting your vendors, your company's vendors have access to that, you're letting them have access to personal data. And I don't think everybody's thinking about that. So then when a breach happens or a regulator comes to knock and you say, you have to answer where your data was, you now realize you have to tap on a lot of people's doors because you unknowingly, in that little clause that's in all the fine print, allow these vendors to have access to all that data that is now personal data. So I think that's the new threat in the new window, is this data aggregation by your vendors.
Yeah, not to be like doom and gloom here, but adding to Myrna's point about this massive shift in the work from home environment, unfortunately, I don't think there is a grace period with the regulators in terms of them like understanding, okay, it's taking time for people to, you know, get up to speed on how we're doing things differently. No, they are going to expect to see that companies have already made real concrete efforts to protect data, even in this environment, have done the risk assessments necessary, done the privacy by design plans already. So if something does happen, you know, we're not going to be able to say, well, in this whole new world, we're, you know, really just learning how to shift to this different environment. That's not going to fly.
That's a great point. And there's this thing called data loss prevention. It's a piece of technology. Take a look.
It is hard to implement though. I'll just go with that, but it's important. Marina, I got you.
We're running out of time here, and I'm just really grateful for this panel and the great questions and dialogue and contributions from those of you here on the call as well. Thank you so much to Davika and Jessica and Myrna, and also Kat and Vianney. Really appreciate everyone's participation, and we'd love it if you filled out a survey. We take those very seriously so we can improve and sharpen our focus on what we deliver to you. And with that, I'll just wish everyone a great day. Again, thank you.